Let's go on the record. No, let's go on the record, and I'll answer it on the record, and we'll be good. Mr. Stump asks, where's the termination date in this agreement? And I just want to go ahead and handle that while we're here. In Section 5.2, the term of this First Amendment agreement, et cetera, et cetera, et cetera, shall continue unless sooner terminated in accordance with the provisions of this First Amendment agreement until December 31, 2023.
Thanks.
You're welcome. There's a corresponding definition of term in the definition section at the end of the PPA.
Is this the right agreement? The proposed agreement? Is that the right thing? That's all I get. Close enough.
For most purposes, it's close enough.
All right, thanks.
But you should have V7, Dan.
Okay.
You should have a red line and a clean of V7. Sorry.
I'll stop by and get one.
Okay.
At this point, clearly we can go forward, but very patiently the public has been waiting to make public comments. So at this point, I'd like to invite any of the public to a presentation. Then we'll return back to the issues and questions we have. Mr. Wilson.
Good morning, Commissioners. My name is Charles Wilson. My address is P.O. Box 651114, Vero Beach, Florida, because I don't want Mark Schuman to know where I live. So the reason I come before you today is you've been doing some history about the 2008 OUC contract. I was there. I was on the council. I threw my body in front of the council to try to stop them from entering into the 2008 contract with OUC. OUC was a bad deal then. We told them it was a bad deal. We tried to stop them. The same group that did 2008 is doing this one. The fact is, I'm not against an agreement with OUC. And I don't think anybody in his right mind would be against lowering rates and shortening the term. We're all for that. The question is, what are we giving to do that? And once again, I believe, unfortunately, that without major changes in this contract, we are doing exactly the same thing. We are keeping our reputation as the worst negotiators since the Indians sold Manhattan. We have run some of these numbers, but you can't run the numbers. Mr. Bavant had an excellent presentation. So did, I'm sorry, what's your name, sir?
Hour,
sorry. And Mr. Stradley, I don't know how you can possibly spend so much time as to find things like you just found, where we have all of a sudden now been told, first we were told it was worthless, it might be even a liability, and now we find that somebody else paid $43.5 million for what looks like a similar number. Now, certainly that would change anyone's calculation. Now, you put that in the same context of what's happening here. And my question to you, I have a couple of questions after I make this statement. What is happening here is that the OUC is demanding an immediate agreement. You're told that they don't want you to make changes, that there's a limited number of changes. They're trying to convince you that this board and that city council cannot make changes. It is written by them and recommended to you by an attorney that was approved by the FMPA. What could possibly go wrong? The fact is that I'm not opposed to this agreement, but even the lower agreement, one of my questions, the lower agreement that they're offering us today, first of all, we don't know what it means to them. Have you added up what it means to them? Are we the worst poker players in the world? I mean, the fact is if we know that what they're after, they need $43.5 million worth of gas. We didn't know that until today. We didn't know. We were told that you couldn't resell that gas. Now we find out, maybe you can get $1 million a year. How many policemen would $1 million a year buy? How many lifeguards can Vero Beach have? What we negotiate today represents a huge difference in the future. And the question I have for you is, are you going to look at this carefully and only approve a contract that's good for the city of Vero Beach? Or are you going to sign any contract because it advances from where we are today? We keep talking about the differences between what we are today and the year 2029 and all the goodies that are given us in this contract, which are two: shorter term, lower prices. We're told that the reason we can't significantly change this and send it back as part of a negotiation is that it will delay our savings of $2.35. We cannot, you cannot, once again, pass recommendations for a contract that includes $50 and $20 million that came out of nowhere. Do we remember that that was hidden from the public? That that was redacted? That nothing was learned about that until the contract was too late? That's how that got in that contract. It was meant as a poison pill. And it's still there. You're going to poison it again if you don't make these basic contracts. The legal, Mr. Bravant, the legal questions are economic questions. Do you know what's going to happen to our economy if under the terms of this contract, when we get to that point, we'll talk about that, but under the terms of this contract, we agree to fight our own citizens. We agree to fight the state legislature. We agree to fight the circuit court. We agree to fight the Supreme Court of the United States. And the person who gets to decide how much we spend is Orlando Utilities. They get to decide whether it's meritorious or not. Do you understand what kind of blank check that is writing? What that does to our community? So my questions are, and it's not an aside question, I want to know from Mr. Wright who he represents. Who is your client? Is it the city of Vero Beach? Is it the citizens of Vero Beach? Is it the three city councilmen that hired him? Who does he represent? That's number one. Number two is this a negotiation or is this an arbitration? Because it appears to me that the attorney will go to Orlando and say, okay, this is, and then he brings it back to us and he says, this sounds like a good idea, y'all should accept it. It sounds to me more like an arbitration than a negotiation. The third thing I'd like to ask him is he told us that you could not resell this gas utility, and he told us that it was probably not worth very much. Okay. Now we're finding out that it's worth maybe $43 million or more. That's a big jump. So
who can prove that?
Pardon?
Who can prove that?
I think, have you seen
Prove
the minutes?
it.
Have you seen the minutes to OUC?
Yeah.
It says in the OUC, now let's turn that around before I negotiate numbers with you. Did
Well,
Mr.
I'm not going
Wright
to negotiate. I just want to know where the proof certain is that this gas can be sold for $43 million or whatever.
Did Mr. Wright tell you that OUC has recently sold this a comparable, what seems to be a comparable amount of gas for $43.5 million? Did he tell you that? Did he tell you that there was a sale? Now, maybe he just didn't know. Then the question is, why didn't he know? How can Mr. Stradley, who's a private citizen volunteering, spend the time to find out that all of a sudden OUC has had a comparable sale for $43.5 million? If that number is different, fine. Find out what that number is. My next question, and my most important question that really will go forward, how can you circumvent Florida's bid laws and change from a lease to a sale, an asset that belongs to the city of Vero Beach? You have changed that. It is not from a temporary assignment to a permanent one. Now, one way you can do it is say, oh, it's not worth anything. We now know that's not true. Or at least if it's not true, if it is true, we don't know how much it's worth. And the only way we can do that is the bid process. So my question is number one, how are we not failing to abide by Florida's bid laws with a contract that changes our gas company from a lease to a sale? And the second thing is, am I the only one that notices who we're selling this to? It doesn't go from us, it goes from us to OUC, and OUC to Fortress. Does that name sound familiar? Fortress is the owner of the train. Fortress is the same company that owns the train. Are we taking our gas rights from Vero Beach, sending them to Orlando so they can send them to the train?
Mr. Mucher.
Mark Mucher, 617 Indian Lilac Road. I originally got up some time ago to speak to the value of the gas contract, but that was before Mr. Stradley's news. But I think you should all remember that when we negotiated the contract with OUC, about the same time we negotiated the contract with Florida Power and Light, that they said they would take our rights for $44 million, and then they would reduce that by $10 million for the gas contract so that we would only have to pay them $34 million, or Florida Power and Light would. Whoever. But I think that pretty much set the value at that time to OUC at $10 million. And from the sounds of it right now, it may be well north of that. I don't mean to be critical, but I think it's probably not the best idea to give away an asset of that magnitude without knowing what it's worth or knowing that it has any value at all. But on the other hand, I want to turn around and compliment Mr. Wright for following everybody's suggestions and going to OUC and apparently securing agreement to first take paragraph 12 out, so we don't have to worry about that issue anymore, and the other concessions to the suggestions that the Utility Commission made a week ago. So I did want to make that compliment. Thank you.
Thank you. Mr. Wright, anything you want to address that I too appreciate that rather than concessions, as I see it, as you explained, they were clarifications. And when you went back to OUC for the issues that were appropriately brought up at the previous meeting. Is that correct?
Yes, sir. You asked me to go to OUC and seek these three changes. I went to OUC. They agreed to them.
Thank you.
Yeah, I mean, I agree. That was good work getting that done. So.
Mr. Chairman,
Surely.
I just have a comment about the super contract with Lake Worth, was it? That I believe people were talking about, why can't we get a deal as great as this deal? Wasn't that a clean contract? They weren't renegotiating. They were starting fresh.
Yes, it was a brand-new contract.
Right. And so at the end of our 8-year contract period, we will be able to start fresh, too.
Also correct.
Okay, thank you.
Yeah, like I said, ours was a clean contract, such as it was in 2008, based on the market conditions at the time, fuel and capacity, fuel prices and capacity at the time, and it was what other people negotiated. The Lake Worth deal was what we negotiated in 2012, executed in early 2013, but they were both clean contracts then. We'll have the opportunity probably in 2022, probably mid-2022, we'll start negotiating for if y'all approve this and we go forward and get a new PPA get the amended and restated PPA, which is, it's amended, restated, it's new. It is the agreement. It's the agreement that we're going to have going forward. But if we do that, we'll have the opportunity for a complete portfolio of new power purchase agreements to kick in 1/1/23. Yes, ma'am.
Mr. Chairman, if I may, Mr. Wright, having negotiated a lot of contracts myself, I understand that you need a willing seller and a willing buyer in order to successfully have a contract. And just because I'm selling something and you want to buy it doesn't mean I have to sell it to you if we don't come to an agreement. The Lake Worth deal that we've spoke about here, you indicated was a timing issue, that time's passed. Same as our investments. I can remember times when we can make double-digit investments, but we can't do that today. We have a contract in place now that will be held to for a number of years. And after hearing the discussion, I think it boils down to 4 items that we have available to us. One, I think, is that we do nothing and keep the contract we have in place for the remainder of the time, which isn't palatable to any of us because we're going to continue to pay the higher rates. If we send you back or someone back to renegotiate this amended contract, we're going to continue to pay the high rates, and no one's under any obligation to make any movement on this amendment as it stands today. The other is to accept the amendment as it is, move forward, immediately lowering some prices, and if we choose to start another negotiation process after that, that would be an option. The other option is we've talked about going out to bid, and Mr. O'Connor explained that process. But while we're doing that, we're still going to pay higher rates, and we're still going to be have the potential for being sued or having another lawsuit coming forward. As I see it, those are the 4 options that all of my colleagues and I are dealing with here this morning. Is that true, or would you elaborate where I have fallen by the wayside?
I don't need to add anything to that. I think that those are, I might add just one clarifying addition, but no, those are the options. Stick with the existing contract, continue trying to renegotiate. That has delays. There's no obligation on either side to get to a conclusion. We have a deal that OUC will accept and that we staff recommend to council and you today. You can accept the new amended and restated PPA, or you can try to pursue the go-to-market alternative. That has, the thing I wanted to add is that has costs and risks. It has litigation costs that are for sure, and it has associated risks, and it has delay costs, and period. And it's hard to quantify those except to say that we have good estimates of what the new PPA will save us, and we don't know when we might get to a point in time that we could actually get back into the market and resolve all of our claims with OUC, et cetera, et cetera, et cetera. Arguing against my own self-interest here, that's not a scenario I think the city should pursue.
Okay, thank you. Thank you, Mr. Chairman.
Mr. Wright, got one further question. On our gas transmission situation, it would seem like in today's market, we could quickly get a value on the gas transmission value from 2 or 3 sources that would be relatively unbiased, that would give a feel for it. That shouldn't take an awful lot of time. We know the values. We're shipping. Gas is a neutral item. Couldn't that be done in a reasonable amount of time without violating our problems with OUC? Or maybe our expert can tell us. I don't know.
Talk about short-term release values in the current market and long-term.
Well, the short-term release is I think it was correctly stated, is less than a year, and it's probably got some value. I don't know, as I understand this thing, we don't have gas transportation. I didn't think canceling the OUC contract was on the table. But if it is on the table, certainly we do have some gas transportation ability then. But
would have
at the termination. So really, right, we've already given the gas to OUC till 2029. So you're talking, I mean, to talk about what the gas market would be in 2029, I don't know. The other thing I want to say, who needs gas? People that are burning gas. We don't need gas. We aren't burning gas. People need gas that are building a 30-year power plant. They aren't interested in a year-to-year release of this thing. They need gas for the time of their 30-year power plant. Right now, there's two ways you can get it. There's excess capacity on Florida Gas Transmission. Florida Power and Light is building a new pipeline in. People are signing up for 30-year commitments on these things to match their need for natural gas with firm gas transportation capacity. I want to say the other thing I was listening is, of course, the LNG. LNG, everybody in the world is talking about LNG. LNG is the greatest thing since sliced bread. LNG, is my understanding, really makes a lot of sense when gas is below $3.50 a million, above $3.50 a million. Gas right now is $2.40 a million. There's considerable uncertainty of what's going to happen in natural gas. They're talking about maybe making an LNG and shipping it overseas. They're talking about bringing it from overseas, turning it into liquid here. I don't. I wouldn't pin my hopes on an LNG facility getting built. It may happen. Will it happen in the next 3 or 4 years? I consider it pretty unlikely. But
OUC certainly talking about it in their presentation. You go to the last 2 pages of my packet. They talk about the Fortress Energy proposed LNG facility. This is from April 2015 on those 2 pages. So. Fortress isn't dummies.
I know they aren't happening, but how long will it take to build an LNG facility? Has it been permitted? I used to work at the power plant where they were at. There's been schemes things to happen at that power plant for 40 years. I started there in 1969, right there on the coast. You got, I can imagine them shipping LNG through Port Canaveral with cruise ships there. I mean, there's just a lot of stuff. It may happen. But like I said, I've seen a lot of schemes discussed related to energy, and I don't see Vero Beach in the natural gas business. I really don't. You're shutting down your power plant. You don't need natural gas. Was it a consideration in the contract? I guess for half the negotiation, OUC didn't want it. The other half, they finally came back with they decided they needed it after 2023. But to place an inordinate amount of value on this thing, I think we're straying from what we're trying to do here, in my view. But if y'all got any other questions about that. But if y'all going to ask me what's going to happen to natural gas, I don't know. I will tell you that. Prices range, as y'all know, in the last couple of years. It's $2.50 today. It's been as low as $2.40 last week, and it's been as high as $11, $12, or $13. That's what's going to drive Fortress. That's what's going to drive LNG. That's what's going to drive the new pipelines into Florida. I don't know what's going to happen.
There was an article in the Wall Street Journal last week, too, that said some of the nuclear power plants are no longer competitive because gas is so much cheaper.
That's right, gas is
a couple of nuclear power plants have been shut down or shutting down in West Virginia and other places because gas is so darn cheap. It's undermining the nuclear power. That's right.
Well, it doesn't really matter what will happen to gas in the future. What's important is what OUC is going to happen. What OUC thinks is going to happen to gas in the future, and what they're willing and what they're doing, and how they're structuring their business practices. They may be making wrong decisions, but they may be valuing our contract. Our gas contracts differently than we are. The fact that at some point in time in the negotiation they said they didn't want it, that's part of the negotiation. That doesn't have much credence. But with respect to just our options to accept this contract or not, as I said earlier, that's the same argument that was made in October. We can accept the contract in October. It would have saved us money. We could have lowered rates in October, but at what cost? There were significant flaws that we agreed in that October proposal from OUC, and the City Council agreed. And Mr. Wright went back and came back with a November proposal, which was better, November 14 proposal. This contract is not as much better as the November proposal, but it is better than the November proposal. Would we have been better off with 2020 hindsight? I don't know. But I do know we have a better offer today. I do know there are still flaws in this offer, the language that OUC presented us that I'm uncomfortable with, that we still haven't talked about. I still want to get a better understanding of how the take-or-pay functions, where that is relative to our usage. Are we at risk of piercing through that floor and paying additional or paying for energy that we don't use? I'm curious as to whether or not how the 54 megawatts of replacement peaking is. Is there actually a take-or-pay provision in that? I'm not quite sure.
The answer to that is yes. We pay for it the same way we currently pay for all the costs we pay for 54 megawatts of the Big Blue combined cycle unit.
But if we...
Yeah, I mean,
You're replacing
Mr. Wright's correct. You need to have that peaking.
No, I agree that we need to pay for
right.
it. But there was the provision, if it pierces below 75, then we lose the 10 million, the discount. There's a lot of moving parts into these numbers that I don't think have been made, for me, clear. And if I'm the only one that doesn't understand all these moving parts, then I apologize, but I don't think I am. And I think we should have an understanding of that. Is there, and I don't want to perhaps get into it now, but just to raise the question, is there a possibility that with the peaking, if we don't need that peaking capacity in the future, how does that pricing structure change? Are you aware of that under this contract?
No, what I was simply pointing out is that we have four options, as I see it. And we can sit and discuss it all day long, and we can be here till early evening. There are some issues that we don't have the answers to. There are issues that you may not get the answers to. My understanding is they don't have to negotiate beyond anything they've already offered. So if Mr. Wright goes back today and starts renegotiating with them, you could do that. But there's no guarantee you're going to get any more information, that you're going to get any better contract. And you know, and I know, they want the best contract they can get while we want the best contract we can get. But we already have a contract in place. And so that's an option that they could pull this off the table, and then we would go back to our original contract. Is that right, Mr. Wright, or is that not correct?
That's a possibility.
I mean, those are all possible things that could happen. That's all I'm saying.
I'm sorry, you made the comment.
Excuse me just a minute, please. So that's all I'm talking about is, as I see it, regardless of how we all choose to address it today, those are our four options, and that was the point I was just trying to make.
Okay. One statement you made was incorrect. You said that Mr. Wright could go back to them to get more information and may not get it. We're not asking for information from OUC. We're asking for information from the city manager and Mr. Wright, particularly if you go to the memo you have on your table from Tammy Vach, next to the bottom paragraph, which was something that came up in the Utility Commission meeting. That information doesn't come from OUC. That comes from the management of the utility.
Look, I understand that. What I was referring to is sending Mr. Wright back to renegotiate this amended contract that they're trying to present to us.
That part,
that's what I was talking about.
Yes, that part I do agree with you. Yeah. To me, and Scott Stradley brought up, to me, the biggest gap in my knowledge at this point to make a yes or no recommendation is that next to the bottom paragraph about how that take or pay minimum demand floor and it's written correctly applies in a way that would impose additional cost in the city, particularly if, even though we're projecting 0.5% a year growth in electricity power, our risk is exactly the opposite. I think all those forecasts are going to go out the window for all the reasons I talked about at the beginning of our session, which I won't repeat. That is my biggest concern, that we get, we put on in this contract an additional fixed cost, and how could that turn around and bite us, where down the line if everybody starts leaving the system because technology changes. That's my number one concern. And and as pointed out by Mr. Wright, that has not been addressed yet. They're still working on it, and that's why I wouldn't vote yes or no until we get that information. That's all.
And this is how we negotiate these contracts. We've gone back to OUC 4 different times with things in the contract that we were uncomfortable with. 4 different times, OUC has changed some of them, all of them. All 3 of the last things that came up on Monday, they changed, and they changed the October contract. We are no longer in the original October offer. They were going to buy our power from St. Lucie Power Plant from us for the term of the power plant. So this transaction was structured that we would get that power from FMPA and we would resell it at cost to OUC. What that did is that prevented us from ever selling that contract, from ever getting free from the liability of that contract, which it's the only contract that we have with FMPA that's not massively underwater. It may be just a little bit underwater, or it may be a break even, or it may be a positive. But that would have kept us in the utility business until that plant not only was shut down, but had completely gone through the cool down process, which was estimated to be 95 to 100 years. We would have had to have maintained a utility so that we, if there was any cost on shutdown, that we could pass those on to our ratepayers. That part of that October contract was eliminated when they came back with the November. They also, I'm not sure, I think they shortened the term of the contract between October and November of 2014. That's correct?
Yes, sir.
Okay. So these contracts is actually negotiated this way because we have to do it in the sunshine. This isn't like private industry. This is the negotiation of the contract. We're right now seeing these terms. We're right now looking at the terms on what is the section where we have to fight statutory, regulatory, federal and state agencies. Under the terms of this document today, we are obligating the City of Vero Beach to fight any rules or regulations promulgated by the federal government. We are obligating the City of Vero Beach and the ratepayers of the ratepayers and citizens of Vero Beach to fight the feds. I don't like that. I'm not comfortable with that. I can understand the litigation, the civil litigation that we're in right now, OUC being concerned about that and not wanting us to roll over. I don't like that either, but I understand that. I don't understand requiring the ratepayers of Vero Beach to take on the Federal Energy Commission if they change regulations that harm this contract. Why is that our problem? Why do we have to fund that fight? I don't like that. We're negotiating that right now. This is how contracts in the public, in the sunshine, are negotiated.
I understand fully after 35 years in public. I understand about violations of sunshine or operating in the sunshine. All I'm suggesting is that if we want this contract or this amendment to be changed, then I suggest that we make that recommendation, because it sounds to me like there are a lot of issues that folks have concern about. And that's my concern, is that let's move forward with this. And if it means staying with the rates that we have currently and Mr. Wright renegotiating, then let's do that. But, we can speculate on these numbers all day long. It's not going to mean anything until this gentleman meets with them and they say, yes, we'll accept it, or no, we won't. If they say no, we won't, then we're back to square one or square two, somewhere in that neighborhood.
Mr. Chairman?
I think what I'm hearing is no one is happy with the contract we have, but it is binding. And OUC does not have to negotiate with us. But because they are, we have something they want. And maybe it's the gas lines, and maybe it's this guarantee of, the capacity that we're going to be tied into. So what we really, I think, are looking for is to monetize these things. Just what exposure do we have that we're getting into that we don't have now? You don't want to jump from the frying pan, into the fire. So it looks like we can get some idea of what the value of those gas rights are. So I don't think you want to go in a negotiation not knowing what cards you have to play. So I think it's reasonable to say, let's find out more about what those rights are valued at, because evidently OUC does want them. And the other is, if we're going to be bound by some kind of minimum payment, on the outset, it looks like it can't be for more than 5 years, so maybe that kind of minimizes, some of the damage. But we need to know what these new costs are to us, our lost opportunity cost and the actual cost that we could incur, so that we're not negotiating blindly. But it looks like, yes, we do want to negotiate, and we do hope that we can have a change in this contract. And to that extent, OUC, they don't have to do anything. But they have negotiated and renegotiated in the past. We just don't know where their floor is, where their ceiling is. But maybe if we had better information on just what our value was, we would have a better handle on what that is.
Mr. Chairman,
excuse me, Chef, when did you start negotiating with OUC?
August of last year.
So it's over a year of negotiations. Perhaps you're saying that until we get every last penny, we continue to negotiate for another year or so?
I want you to have all the time you want. Let me talk.
please, I want this to go well.
So do I. Thank you. I'll just tell you all straight up, I don't think there's any more money there. We had a meeting with the CEO, the general counsel, and their senior vice president of the business unit, Jan Esperu, Ken Kashanik, Chris Browder, Jan Esperu, and I think they had one other person there, and the mayor, Mr. O'Connor, and I. And we pushed them a lot. Ken Kashanik said, subject to my board's approval, I can do this, but this is it. I don't think there's any more money there. To the extent that gas transportation contracts have value to them, and obviously they do, and whatever happened in June was, to be blunt, the puffery that goes on in negotiation. But leaving that aside, the deal we have is the deal we have. Could we get some other things changed? Yeah, we got 3 things changed. Last week, you all said, please go ask them to change these 3 things. I went to them. They did. But the money, I think, is done. I think whatever value the gas transportation contracts have to OUC is baked in the cake, as we say.
In my negotiations, and I have also done, again, in the private sector, is that there is a notion of best and final offer. And when you get a best and final offer on both sides, that is exactly what it means. You either accept it or you reject it. Now, I don't know whether those terms were used, Mr. Wright, whether this is a best and final, or whether it is, as you're saying, still open for further negotiation, and at what risk and at what price and how long?
Mr. Chairman, may I rebut, please?
What public comments for?
Thank you. Well, the first is the nice gentleman that is our consultant. He's a nice fellow, and he's certainly very, very knowledgeable. He probably has not had a chance. I've just read the minutes from the OUC the OUC council meetings, and if he's saying that there may not be a plant, or what the chances of there being a plant using this energy, Orlando Utilities just spent $43.5 million betting that there is. So they are pretty much convinced. that the plant is there.
And the city of Vero Beach bet on natural gas versus coal when they signed the 2008 contract as well.
I wouldn't bet with the city of Vero Beach ever. I don't.
So whoever, what side you want to bet, it's a bet.
Anyway, here's what I want to. This is the rebuttal comment that I have. The gentleman, and I'm sorry, I don't know you well, so I listed some of the options. And as you go through some of those options, Ms. Barton's comments were well taken. That when you look at some of the options, one of the options he listed was staying in the current contract. Well, we need to throw that out because the current contract is terrible. I'm the one that called it terrible to start with. It's still terrible. But you equally have to look at the contract that's before you, because the contract that's before you is equally horrible for 3 or 4 reasons. Now, it comes down to 3 or 4 reasons. So maybe it is time to look at some compromise where we all go forward. But because of those horrible provisions, you can't just vote this contract as it is. If nothing else, that legal...
We can vote whatever the commissioners vote on.
You shouldn't vote without the information for a contract that has the provisions in it that you know are harmful to the city of Vero Beach. Now, you certainly have that right, but if you really look at the options, you really have to throw out staying, and you really have to throw out what we're looking at today. What you also, the next option you have, however, and Ms. Barton is right, we have a binding contract, but part of that binding contract gives us a provision to pay a penalty and leave that contract. It's the same contract. And so the option we have is to do this. There is nothing wrong with sending a request back to OUC. What are they going to do? All they can do is say no. You know? The fact is that if we tell Mr. Wright as an example, and the reason we need to have action, and that's why we can say and talk about it all day, you're right, but it is a contract that lasts forever. So maybe we should spend a little time on that. When we give those gas rights away, we give them away forever. So perhaps what we should do, here's an idea. What if we sent back something that said, we want Lake Worth rates, we'll pay 75% of the take or pay instead of all 100% of the take or pay. We want to eliminate all of those requirements for legal action. And we want the acknowledgement that in return, we will acknowledge that for 8 years we won't go to market. And what you get is 8 years of sales, and you get a $43 million gas utility, and you don't have to worry about your loss of capacity during those 8 years. Okay? There is no reason why we can't negotiate from the point of view of what's best for the city of Vero Beach. And the reason that we need to have some action is because Mr. Wright has to have direction. If Mr. Wright doesn't have direction either from this board or the city council, then he's going to go do what you're looking at today, because he doesn't have direction from you. Now, the city council is scheduled to meet on the 20th of this month, I believe. The 19th of this month, thank you. The 19th of this month to vote on this issue. You know? So if you just say, we're going to take what we got, and we're not going to make any recommendations, we're not going to give Mr. Wright any direction, we're not going to give the council any direction, they're going to vote. Okay? And my plea to you is to put politics aside, put personalities aside, and look at the provisions of this on behalf of the citizens of the city of Vero Beach. Because the provisions that are in here are terrible. Terrible.
Charlie, before you leave that, those are pretty inflammatory statements. They're terrible and all this. Give me 3 very big things that are really terrible about this contract. Tell me dollars. We're talking in dollars. Tell me dollars. What are you talking about?
In dollars, let's the take or pay. If you took, I'm just taking advantage of saying 85 to 75 that protects us against loss.
You think that's a major problem?
Protects us against. I think going from take or pay is a major problem.
My expert over here thinks it's a problem, but it's not a disaster. But okay, let's.
Okay. I don't know what it is because I don't have the information. That's all I'm saying.
Okay. It's not disaster. It's not take or pay.
Okay. The disaster, the legal provisions. Look at the legal provisions. What that does financially.
I agree with you, Charlie. The legal issue is an issue.
Is a disaster.
I agree with that. Okay.
So I just listed the 4 things to do. Deal with take or pay. deal with stranded costs. You know, what we've been told so far is the stranded costs, we'll negotiate that later. Well, negotiating with OUC hadn't worked out very well. So deal with stranded costs, which includes our penalty. What if we ask instead of the 50, we do 20? You know? So deal with stranded cost, deal with the take or pay, deal with the legal issues, and deal with the provisions of the gas utility, because we could get sued for not following bid practices in selling the gas utility too.
All right,
so if you deal with those four things, if you deal with those four things in a way that's legal, pending this exception to the law, I'll stand up and tell everybody I know that this is a good contract and that it's good for the city of Vero Beach, and we should all work together. So that's a compromise. Send back an agreement that deals with those four things. I don't know if I've given you the right way to deal with it. It's probably fairly close. If you get that back from OUC and they say, we'll agree, I'll stand up with you. I'll stand up with you and say, this is a good deal for Vero Beach.
Okay.
Charlie, I'd like to make one statement. Your comments about Mr. Wright and about this board. Last week, the Utilities Commission handed him a very clear set of recommendations that we voted on.
Good job.
You made the suggestion that he's not listening to anybody.
I did not.
He came back and it had an answer to every one of those things.
I think he did a great job of taking care of those things, and now I need him to take care of these 3 or 4, and then we'll have a good contract.
But, you know, this could go on for quite a while. I'm just saying he has demonstrated a response to our requests.
Mr. Wright is a learned, fine attorney, and he's doing a fine job for whoever. And I agree with him now that what he needs is direction, and he will do it. He has not lied to this council. He's been very careful.
And that's what we're here for.
Yeah, he's not lying. He's told the truth. I would wish that he had known this about, because he likes it. He has colleagues at OUC that he trusts, and I would find it personally offensive that if I had colleagues that I trusted and they didn't tell me that they had a $43.5 million purchase that was similar to the one he's telling you is worth nothing, that they probably should have told me that. But I have no quarrel with Mr. Wright, his ability or his honor. I do have a question about whether, in 2008, you know what the problem was? We had a passive city council that listened to their consultants and their lawyers and said nothing. And we had a public that did not stand up and protest and spend hours and have people say nasty things about them. We need to have both of those this time so that we don't repeat that last problem. So there's a compromise out there. Let's all work together. We can do this, but certainly not with this.
Nobody's been passive in these meetings.
Let me
just go back to the 4-hour meeting last Monday. I think Mr. Wright would agree with that.
On my feet.
Yes, exactly.
Mr. Wright, coming back to the legal issues, and I think that is a major problem for the city. But when you look at the contracts as they now lay out, I mean, we're really talking about under a $300 million contract over 8 years. That's really what it amounts to. And it would seem like the logical approach to the legal issues would be to tie a percentage expenditure max for legal bills, pro rata maybe the length of the contract. In other words, it'll make no sense to anybody if we say, this occurs in the 7th year, and we got to spend an exorbitant amount of money for defending these contracts. Whereas if we said our upper limit in that paragraph is 5% of the remaining balance of the contract, or something like that. I'm just throwing numbers out, trying to get a stopple at the top.
Or maybe a different way to look at it. Look, I hate this section 1511.2 where we have to go to the mat everywhere. But assuming we have to keep it, what bothers me is OUC has no skin in the game. They have a free option. They can say go litigate, and it's all borne by our ratepayers. I would do something like, at a minimum, say that for the first round of legal cost where you're at the initial level in the court system, it goes 50-50. As you move up into the appellate ranges, OUC has to bear an increasing portion of the cost because they're going to be the ones motivated to do that. At least, they don't have a free option anymore. They have to go to their board and say, okay, we want to do this, and maybe their board will push back. So, short of getting rid of this section, that might be an approach. Maybe combined. I think your number would be so high that it wouldn't make any difference anyway. But at least this way, every time they got to go back to somebody and say, we got to go spend money, and we're going to have to
there ought to
pay.
be some cap in it, some relationship on the cost. So we're not sitting out there with an open checkbook representing a company that got 10 times as much money as we do. That's just silly. And we're sitting in a court, we could be in federal court, and they can drag us through years of litigation. That's an open checkbook we just can't afford. We ought to be able to find some upper limit. Maybe a shared cost, maybe a percentage cost declining, because the contract is going to be less and less value as the years go by. Theoretically, right?
The last statement is not theoretically true. The contract is less valuable as it gets closer to its termination. Our stranded cost exposure, as to the OUC contract, gets less and less. If we have the catastrophic event, we might be litigating over FMPA, over stranded FMPA.
That's a different story, though.
Costs, which is a
wholly
different thing.
Yeah, that's a wholly different story. Yeah,
and other costs too.
But that's not related to this contract.
No, you're right. It's not.
Those are other.
But my simple point is, we may well be if we have the catastrophic change in law, the bad legislative or judicial outcome, we may be litigating anyway.
That's a whole different.
OUC didn't. To be very candid, OUC didn't want us to be able to just say, "Oh well, never mind." It's really that simple. They didn't want us to use this as a free pass to walk away and leave them without the benefit of their bargain.
I would agree with them.
Well, Mr. Wright, what's your reaction to my proposal about percentage sharing, and then OUC has to take a bigger share of the burden as we move up through the appellate process?
I think asking them to share in the cost is not an unreasonable ask. Whether they will say yes or no, I don't know. I would probably set it at a fixed percentage and just go with that, rather than ask them to bear more and more of the cost the higher up we get in the legal process. That would be my thought.
It's easier to understand in the contracts, but I'd sort of lean that way too. But
I think both of those suggestions are good. I like both of them. I'd like to clean up the language a little bit and not have us have to. Let me just read what it says. If to the extent that after the original effective date of this agreement, any laws or regulations, and listen to this, including any statutory laws, judicial decisions, administrative orders, rules, regulations, or other directives from any state or federal government, agency, or entity, which govern any transaction or duty of the party contemplated herein, shall change, any such individual law, decision, order, regulation, or act, being a change of law, and collectively the group of such potential government laws, orders, regulations, or acts being changes in laws, so as either directly or indirectly to make this agreement unlawful or increase the cost to OUC of providing energy and capacity to Vero Beach, or that negatively impacts the ability of Vero Beach to perform under the First Amendment agreement, then OUC and Vero Beach hereby agree to use reasonable efforts to attempt to agree on such modifications. Okay, if we can't agree, and then Vero Beach commits to use best efforts to contest and reverse any such change in law, including challenging the validity of any such change in law, whether such change in law is statutory act, judicial decision, administrative order, or governmental act or directive. I don't see why OUC wants the city of Vero Beach to fight federal agencies if they do a rule or a regulation or an order that would change this contract. I don't see why they expect us to agree to that. I think it's really nice. I can see why they put it in. I understand why OUC wants us to fight the lawsuits that we're currently in. I understand that OUC doesn't want us to just roll over in those lawsuits. But I don't understand why OUC expects us to fight the Florida legislature if the Florida legislature changes the way territories are allocated. Or I don't see why we're responsible to do that and fight the constitutionality of that statute. Presuming that if that were to happen, that's an example. I don't think it's up to Vero Beach and the ratepayers of Vero Beach to fight that. And I don't see if one of the myriad of federal agencies changes a rule, a regulation, an order, or any other directive that materially affects this contract, the city of Vero Beach and the ratepayers of Vero Beach have to fight the federal government. I think that's a losing provision and an unconscionable position to impose upon the ratepayers of this utility.
I agree. And by the way, it's also making the assumption that we would always be on the same side with OUC. Some kind of change might occur that would benefit us, not benefit them, but then according to this, we're obligated to be on their side and fight that change. I don't think we should be obligated to any of it, frankly.
Now, if the federal or the state legislatures pass a statute that only applies to the city of Vero Beach, that no one else would be impacted by such change, I understand the language, but I also understand the reality if a change is such that the industries itself is impacted other than just the city of Vero Beach. So I just want to make that comment. And the other part is that if whatever the recommendation would be on legal action, you go to OUC, and if they agree, fine. And if they disagree, just accept the existing contract as it stands. Correct?
I'm not sure, Mr. Gorey, if you think that this language only applies to laws or regulations that would only affect Vero Beach. I think this applies to anything, and I think that if it's an industry-wide change, as when the county went to the PSC and requested information on what happens to the territorial agreement when the franchise agreement expires, the utility industry has made a virtually united front to the PSC, saying that the PSC controls the territorial agreements, not the franchise agreements. And I might be missing some details on that, but the point that I'm making is that the industry had a united front. Vero Beach wasn't standing there all alone. And this requires us to stand there all alone. And I think that I also have a question about the language with meritorious appeals. We have to agree to make any appeal that the two parties believe is meritorious. If they think it's meritorious and we don't, I believe, and correct me if I'm wrong, that the arbitration provision earlier in the contract would take place. And if just the general disagreement, there's a provision.
Dispute resolution.
Dispute resolution. If we don't agree through dispute resolution, then it goes to court. Now we're disputing whether an appeal is meritorious or not, going to court over that. And this is with an organization that has told us that the penalty provision, which says it's the maximum amount of penalty that they don't believe what the words on the paper say. So I don't trust them to be rational or reasonable in any discussion of meritorious appeals in the future, because they've been irrational, and unreasonable in a discussion of the penalty clause in the past. And I think that is substantially different than just saying, gee, anybody can argue about any provision over a contract. Well, this is a provision in this contract that says something in plain language that they read it to say the exact opposite. So I don't trust OUC to be rational or reasonable in this discussion about meritorious appeals. I could see OUC threatening to sue us if we don't take a change in statute all the way to the Supreme Court, and challenging the constitutionality of it. And I don't want to put our ratepayers in the position of fighting the state of Florida. I don't want to put the ratepayers in the position of fighting the federal government.
So the bottom line is that if OUC doesn't accept the change, welcome to 2029.
This is, well,
Mr. Chairman, there is enough uncertainty here among different numbers. There's a lot of good questions being asked. Noah asked a good one. I made a good common sense statement that there are too many issues here that we just don't have answers for. So I don't see what is the harm in asking for say a 30-day.
Why?
For Jeff to go back and continue his good work. He's gotten some answers that we've asked. Maybe we could get some questions. This is chapter 15.11.2. That's broad. I mean, that's asking us to defend, trying to overturn laws. I mean,
it's asking us to defend. It's asking us to defend the fundamental economic bargain to which we have agreed. In the event that there's some exogenous change in law event that impairs our ability to, really impairs our ability to perform our duties under this contract. And ultimately, it's got to wind down where we can walk away from the peaking capacity, reduce. If everything falls apart and we lose, we get out of the peaking capacity first. We start reducing the base product. If it falls below 75, the demand charges revert to the old demand charges. And if it gets low enough, OUC can walk as a termination period.
Yeah, but what concerns me is we have at the risk of jumping on the bandwagon, is we have to go up against something that could be just completely industry-wide. I feel like we're going to be Don Quixote, trying to go after the windmill.
Well, here's the scenario. The real scenario that's industry-wide is federal legislation to mandate full retail competition nationwide as a matter of federal preemptive policy. If that happens, I'll guarantee you we will not be alone. We will not be alone. Every other retail serving utility in the state of Florida, and probably FMPA and Seminole, the wholesale-only utilities, will be right there with us, because that is a sea change that's going to materially adversely affect almost everybody except those who charge the lowest rates, who, when we go to market prices, will make more money.
But we don't know that it will be that. I think that's the biggest problem, that we don't know what it will be. And it's very broad. You must admit that. It's very broad.
It is very broad. I'm not going to agree that it was unconscionable for OUC to request this. They want to preserve the economic bargain to which they have agreed in giving us the concessions they have given us that are non-trivial.
Yeah, and their resources are much greater than ours.
Well, again,
except that this clause was written into the contract before there were any concessions.
Pardon?
This clause 15.11.2, that was part of the original contract.
No, sir.
Oh, this is
no. There was a 15.11.2 in the original contract, but the material changes that we're debating here today are new that would apply with the new deal. The new lower pricing and the new shorter term.
I've read that clause too, and it is a very broad clause. And I've been in a lot of contract negotiations too. And unfortunately, I think this is a pretty important paragraph to them. I think it's more likely we can get them to share costs a bit, or at least mitigate our upper limits, than it is that we can, as maybe implied, strike the whole paragraph. I just don't see that's going to happen. My own analysis is probably unlikely they will. I think they might very well put a cap on how much money they expect us to spend, and they ought to. That's reasonable. They ought to look at the contract just as we would, as a declining value contract. And certainly as we get out 4 years hence or 3 years hence, it's got less value. And they certainly would not be thinking that we're going to spend bukus of money to validate a 2-year deal or a 3-year deal or a 5-year deal. So I think we could better serve us by putting a percentage in there or a shared cost in there or an upper limit and see where that takes us myself.
I'm not suggesting we get rid of the whole paragraph. I'm suggesting that I don't have a problem understanding OUC's requiring this with respect to judicial decisions. I'm not happy about it, but I can accept that. My problem is the federal regulation issues, agencies, orders, rules for state and federal agencies.
Could you present that paragraph redlined? What would you take out, Mr. Stavely, if you sat there with a red pencil and you were a little lawyer this afternoon? What part of the sentence would you take out?
Okay, I would take out the effective date of this amendment, any judicial decisions which govern the transactions duty of the party contemplated herein shall change, and then conforming to that, the Vero Beach commits to use in its best effort to contest and reverse any judicial decisions, and I might limit it to Florida. Such change in law. It says change in law, which encompasses everything, but I would limit it to the judicial decisions. I can understand OUC does not want us to roll over in these lawsuits. And also, it leads to another question that I have with respect to the conversion of this contract to one which now includes stranded costs. But that's an answer to your question. That's how I would change it.
So only judicial decisions, no statutory laws, no administrative orders, regulations, or anything like that?
No.
Was that your suggestion?
That is my suggestion, yes, sir.
And did you say only state judicial decisions?
Yes, I would limit it to the state. I would limit it to try to encompass the two local entities that are currently suing us in those types of lawsuits. We are currently involved in litigation, and I can understand that they would want to have some protection against our fighting this litigation.
So our best efforts would be limited to filing an appeal of any judicial decision that was adverse to us that would make this.
Any meritorious appeal.
It would take out the categories of actions that we were obligated to challenge. It would leave in the obligation to take meritorious appeals of a state judicial decision. Right, Scott?
Yes, sir.
Would you also want to set that 50% that we spoke about earlier?
Yes, I thought that was a very good, and also a declining economic, that there'd be language that would affect the economics of the total transaction with respect to the projected litigation costs. I thought those were both very good suggestions. Particularly the further along you get in the appeal, I actually like the escalation clause. It's much more expensive to appeal to the Supreme Court than it is to appeal to the Circuit Court. So,
is that true?
I have filed one petition for a writ of certiorari to the United States Supreme Court. It was not particularly expensive.
Okay.
There's a pretty good printing bill. It was $5,000. This was 14 years ago, so it's probably $8,000 for the printing because they have to be perfectly bound and so on and so forth. If it's $5,000 for the printing in 2001.
Oh, I wasn't referring to actual.
Did the court take the case?
They did not. I am sad to say.
Yeah, I think that's where the.
But the fees were not astronomical at all.
I don't mean the court cost. I'm talking about the total cost of the litigation. I think that.
I thought we were talking about the meritorious appeals to the United States Supreme Court, and I'm talking about the cost of taking an appeal to the United States Supreme Court.
Yes. Okay. But also, we have the lawyers, and I think that you have different teams of lawyers for different courts and different levels of expertise and different billing rates.
The whole cost of this could be pretty expensive. I'm just telling you that my experience taking a writ to the United States Supreme Court with two experts from FSU law in con law and federal energy law as part of our team was not real expensive. I mean, it wasn't $30,000 all in to get to that point of filing the motion, the petition for writ.
Yeah, your costs start when you go in front of the court and have to.
They would. There's prep time and there's showing up time. You know, it might have been double that to actually go up and argue the case if we had been fortunate enough that they had taken cert, but.
All I would say, after hearing Mr. Wright's comments, to make it maybe a little bit easier to negotiate, I mean, I would be comfortable with just making it a 50-50 split all the way up the chain, if that makes it easier to get it on there. I mean, I don't see how they could push back. Well, they could push back on anything, but I don't see how they could reasonably push back on that by having skin in the game.
Well, it's 50% apply to our existing court cases. Is that what you're suggesting?
No, I'm talking about any future litigation driven by this section. Yep. That's what I'm referring to.
I will tell you, I don't think losing the shores implicates, that's the word I wanted, implicates this provision.
Well, that was my question.
No. This is the big loss. This is where we lose the ability to serve everybody outside the city limits. But I got a couple of things to add to the conversation. If we were to drop from 85 to 75 megawatts, the net cost is the difference between what the new demand charge would be, and this is relative to the new PPA, the amended and restated PPA. The net cost is the difference between what the demand charges would be, which is $12,442 in 2016. It's $12,442 times 12 times 75 versus what it would be at the new rates without the floor, which is $10,978 times 75 times 12, and that difference is $1,300,000 for that year. And remember, the demand charges fluctuate up and down. Actually, in the 16 rate is almost as high as there is in the whole term, and it's lower in some years. If you multiply that times 8, you're looking at $10.4 million, $10.5 million nominal total over the term.
I have another question, though, but since this is a new provision, we presumably would not be the only people affected by any legal changes. In other words, as written, it sounds like we and OUC would go fight the Supreme Court, but what about all the other clients of OUC? What is their skin in the game?
It would depend on what the change in law would be. Well, if it's we lose a big court case, or we are the subject of an act a legislative act that takes away our ability to serve customers outside our city limits somehow or other, which I think would be of dubious legality to start with, and I think a challenge to such a legislative act would be meritorious from the get-go, and suits for stranded cost recovery would be meritorious from the get-go, because I think such an act would be an impairment of contract, an unconstitutional impairment of contract under Florida law. That's my belief standing here today. if it only affects Vero Beach, it only affects Vero Beach. Mr. Stradley and I had a conversation, and a good one, about what happens if there is an industry-wide change. What happens if the Florida legislature, like the legislature of 20-odd other states, enacts some form of retail choice? In that scenario, we're not going to be alone. All the other utilities in the state will line up with us because they don't want that. I will guarantee you. I represent the Florida Retail Federation, who does want that. And I will tell you what, the retail serving utilities in the state of Florida and probably everywhere else don't want anything to do with that.
Understood.
We'd be lined up, we'd be one of 55 plaintiffs in that action.
But this is non-specific, so we don't know that we won't be alone, and we don't know even necessarily that we will agree with the lawsuit, but we'll be tied to it. We'll be fighting their fight because of this contract.
It'll be our fight, too, because we will be the ones on the hook for stranded cost payments.
Well, you're talking about a specific scenario. I'm talking about the wording of this contract. We don't know what the matter will be exactly.
That's right, we don't.
And we can easily get dragged into their fight.
Well, let's try to resolve it a little bit here. Mr. Wright has been here for 4 hours already.
Three today.
Three.
Last
Okay.
week. 7, depending on how you count.
Do you think, with the modifications that you've been thrown at, can you try to implement that to satisfy the group and maybe tie in the percentage dollar commitment? Now, I don't know if a 50-50 works or 25-75 or some cap works. I think you get from this group, if you could get something in there that makes people feel better about our total exposure on the deal financially, that goes a long ways to taking some risk out of the deal.
I will make the ask. I'll make the full ask. I'll ask. I'd rather not ask for this graduated, the more it is, the more they pay. I'd rather ask for 50-50, and I'll make the ask that it apply to state judicial decisions.
Do you have a problem with that? Does that work?
No.
That works for me.
Okay.
All right.
Yeah.
Works for
Scott,
you?
what's your thought?
Yeah, I think it works, and it does.
Okay, that's resolved.
Now, with respect to one of the fundamental changes in the contract is it moves from it defines this contract as a stranded cost,
Yes.
and OUC's cost in this contract as equivalent to a power generation facility.
Our
correct?
costs,
Our
our payments to OUC.
Our payments to OUC. So as I understand it, then, in the event, and there's a provision that divides that up, and that got clarified, in any recovery of stranded costs, in the event of a sale or a loss in the court, any recovery of those stranded costs would be allocated with respect to the percent of the total stranded cost versus the OUC stranded cost, or payments to OUC.
Correct.
Correct. Okay. But at this point, that denominator is 0. We don't have any stranded cost to OUC.
Also correct.
Oh, okay.
Yeah, and we wouldn't have any stranded costs to OUC unless there were some adverse change in law that caused us to thereafter be unable to recover our costs.
True, and there would be no stranded costs, but there are costs that would, the stranded cost would survive the demise of the contract. You would have to reimburse them for that to the extent that we're reimbursed for it. If we were to
Yes.
lose, okay. So
yeah, if we lose,
what I'm trying to do
if
is
we lose the litigation and we sue for stranded cost and we're successful, it'll be based on some presumably, and I would expect, larger pot of dollars that we would be demanding as stranded cost recovery as a result of whatever action it was, and then that would be split as we've agreed here.
Okay, and I'm just trying to understand the change and that we're moving from the contract we're under to the contract we proposed.
Sorry.
So
I
if
missed.
Judge Cox today
Right.
gavelled down, I know it's not happening today, but if she gavelled down and said, Vero Beach, you lose, Indian River Shores, you win, our obligation to OUC for stranded cost as it exists today
Under
is zero.
the existing PPA.
Under the existing PPA is
Correct.
zero.
That is correct.
If we amend the PPA, then our stranded costs are some number of our payments that would be made to OUC over the term of this agreement. That would represent, and we're defining it that it would have the same definition as a power plant, a power generation facility. Okay.
Yep.
Would that also hold true for any sale, any partial sale of our base, our customer base?
No. Partial sale is a voluntary act. It's not a change in law.
Okay.
So, it is addressed by Section 15.11.3.
Oh, okay. But the stranded cost issue, if right now Florida Power and Light's offered us $13 million, and we've said it's worth 65.
We've said the amount, our estimates of the amount to keep all of our remaining customers inside the city and in the unincorporated county and the citizens of Vero Beach whole is $65 million.
I appreciate how clearly you define that, but fundamentally they've offered us 13. We said now we need 65
to keep us whole.
To keep us whole, and maybe somewhere in between those two numbers is a number that we could agree to.
Mm-hmm.
Okay, so let's say we agree to a number, and it is XXX.
Mm-hmm.
Okay, just I don't want to give a number.
Sure.
Okay, but we agree to a number. How does this change in the contract affect that transaction?
The peak demand would be reduced by the shores piece of our peak demand. That reduced peak demand value would then track through into the computation calculation of the amount of supplemental wholesale base electric capacity, the base product, that we buy.
Not the peaking.
Not the peaking.
Okay.
Because we got to have enough to serve our load.
Right.
Okay. If that net result was 10 megawatts reduction, it would cost us, as things stand, it would cost us in 2016 about $1.3 million. It would cost us whatever it would cost us based on the calculation. If it was 10 megawatts, it would cost us whatever it would cost in the succeeding years. Those are numbers. It's a system planning problem, but those are numbers that, based on peak demand projections and so on. It's a calculation that could be done. We could add that up, and we would ask for that. I would presume, again, trying to keep the city whole and trying to keep the rest of our customers whole, so we don't wind up paying more because we sold off the shores. I mean, the folks in the county and the folks in the city would have a legitimate beef if we did that.
Sure.
We would ask for that much from. As part of whatever we would ask for in a partial sale. Whether we got it or not, we would be obligated to pay OUC that higher amount. As I said a minute ago, if it's 10 megawatts, it's $1.3 million in 2016. It'll fluctuate over time.
Now, when you say it's 10
charges.
megawatts, is that because it pierces the 75 megawatt take or pay?
Pierces the 85 megawatt take or pay by 10 megawatts down to 75. And the impact of that is an extra cost vis-a-vis the new payments under the new amended and restated contract of approximately $1.3 million in 2016.
So I think I'm coming to understand this. So whatever the reduction in the demand, whether it's up to 10 megawatts, we pay the same amount in the future that we would have paid for the 85.
That's exactly correct.
Okay, so whatever the price is for 85, that's the price for 75.
Also correct.
Okay. What happens if it pierces the 75?
The 75 is just an example. If it goes below 75, the number will be a little bit higher. Well, or a lot higher, depending on how big it gets. If it's catastrophic, it kicks in 1511 too. By catastrophic, I mean basically losing our ability to serve everybody outside the city.
Okay. And
if it's 84,
if it's
84, it's 1 megawatt worth. If it's 83, it's 2 megawatts worth, et cetera. But it's pro rata. It's a formula. It's not the 75 megawatts is an example. It's a formula.
Okay, where does there's another provision in here that has to do with 10 megawatts and 75 megawatts that has to do with we lose the discount. That's a different provision. They're giving us a discounted.
Yeah, right. That's one of the fall-throughs in the waterfall of what I might call the parade of horribles of starting with a seriously major adverse change in law, whatever it's going to be, judicial, legislative, or otherwise. If everything happens adversely, we sue and we lose, and we get to shed all the peaking capacity first. If we're still shedding capacity after that, and we start lopping off that from the 85 megawatt floor, if we get down to 75 megawatts at whatever future time this occurs, the demand payments would revert to the demand payments under the old contract. That's the other 10 megawatts you were talking about. If it gets low enough that OUC says, this 18 megawatt contract, it's hypothetical, I'm making the number up. This 18 megawatt contract is not worth us fooling with. We're terminating. They terminate, and that's it. We're done. We shake hands and walk away. But that's the other 10 megawatts you were referring to, Scott.
No, there was a discount. We're getting
the 10. That refers to the starting point under the PPA as it stands today,
which is 190. Is that 191?
It's 100 next year. It's 191.
191 next year. Base capacity.
165 times or 166 times 1.15 gets you to 191. The 1.15 is reserve margin. Subtract 106 from 191 is 85.
Okay.
Okay. If we didn't have that, that's the floor. Starting with 166 and adding 150.
Okay. What's the floor?
It's 85, period. It's 85 for the whole term of the contract. That's the minimum take provision that we've been talking about.
Okay.
If we didn't have the option to reduce our peak demand by 10 megawatts on the going-in piece, on the going-in calculation of what our payment would be next year, it wouldn't be 166 times 1.15. It would be 176 times 1.15, which is whatever it is, about 202, and 201, 202, somewhere in there. 202 minus 106 is 96 megawatts for which we would be paying. In that scenario, if we didn't take advantage of the option that they gave us to lop 10 megawatts off the peak demand, we'd be paying for 96 times the new rates next year. So getting them to agree to that 10 megawatt reduction in our peak demand was a significant concession by them that we got in February. Did I talk too fast?
There's a lot of moving parts here.
I have said that many times.
All right, let me try to explain it back, and you can tell me where I don't understand it. We need base capacity of our highest day, projected day, plus 15%.
You just used what is potentially a term of art that may confuse things. You said base capacity. We need total available firm generating capacity equal to our projected peak demand plus 15% for reserve margins. OUC has agreed to let us reduce that projected peak demand by 10 megawatts, less than what they project our peak demand will be, based on, as I understand it, their regular planning assumptions that they apply to all of their load. That's a break for us. If they didn't do that, we'd be at 201, 202 in what we needed in terms of our total required capacity to meet our projected peak day, 176 in this example, plus our 15% reserve margin requirement.
Okay.
Okay.
All right. And I appreciate that they're giving us that 10 megawatt break. I don't quite understand if this is a real being a bean counter. If I counted the beans, I don't understand where that number goes, but I'm glad to take it because it's in our favor.
It's about $1.3 million next year.
No, I'm not talking about
it's
dollars. I'm
10,000
talking about the megawatts. If we
Okay.
need it, we need it. If we don't need it, we don't.
Yeah, and we had the discussion with them, and we said, we don't think we need it. And they said, we think you do, but we'll give you the break in terms of
Okay.
your pricing under the contract. But we're not going to let you game the system. If you wind up going over, we're going to hit you with this capacity deficiency pricing.
Okay.
Okay?
All right. So to close down our power generating facility, we have to replace the 54 megawatts. And that's, you're calling
One way or the other.
One
Yes,
way or
sir.
the other. We have
One
to
way or the
replace
other.
that. We have to replace that capacity.
We've got to have sufficient total firm capacity plus reserves.
And you've called it peaking capacity, but it's actually firm capacity as well.
But
it's replacing our peaking
and base
power plant.
Yes, but peaking capacity and base capacity are both species. Well, in this context, they are both species of firm capacity. You could also have non-firm capacity, but let's don't go there.
Okay, we won't go there. And we're committed to an 85 megawatts take or pay of our firm capacity that we're getting from OUC. So we have firm capacity from the
It's 85 megawatts of the base product, 54 megawatts of the peaking product. And we are committed to both of those.
And are those capacities for the capacity payments priced differently? Is that why you distinguish them? They're priced differently?
Correct.
Okay, that's what I thought.
And we're also committed to what is today 52 megawatts of our entitlement capacity from FMPA.
Okay.
Under our 3 projects. That can also change.
If we lose capacity, the need for capacity, and we lose the 54 megawatts of peaking capacity?
Only under the change in law provision.
Okay, not under a sale.
Correct.
Okay. If we were to make this sale, how would that affect our cost on the contract? Would we continue to have to pay for the 85 megawatts and the 54 megawatts?
Yes. Yeah. Effectively, we have to pay for the 85, and the reason for that, from OUC's perspective, is that's the bargain they're giving us. That's the bargain they struck in return for the reduced pricing in the shorter term. And that's why what 1511.3 addresses is keeping them whole where they would be if we sell off part of our system or something else unexpected happens, other than a change in the law.
Okay. 1511.3 just says that we're going to pay for 85 no matter how much we use.
Correct.
And what part addresses the 54? Where do we address 54?
Hang on. Section 3.2 addresses that. Article 3 addresses it in a broader way, in that it defines wholesale electric service as the provision, the supply of. This is page D7. It's almost at the very back of the PPA. The supply of supplemental wholesale base electric capacity and energy, which is the base product, and the supply of peaking capacity and associated peaking capacity. Those are the components of, those are the power components of wholesale electric service. It also includes administration of our generation entitlements during the term, administrative oversight of the power plant to the extent it's still running, generation planning, and annual calculation of our peak demands.
Okay, and again, now that I think I understand it better, and hopefully everyone forgives me if they all understood it before, what is the scenario where we lose the 10 megawatt discount that they've given us?
That scenario is one of the eventual consequences of an adverse change in law provision that we would hypothetically be unsuccessful in reversing.
So not only do we have to pay for it, we have to pay more for it. Do we have to pay for the 85? If we lose a case, we have to pay for the 85 and we have to pay more for it?
No. If it falls below 75, if going through everything bad that happens, we shed the peaking capacity, gone.
I thought that was a take or pay.
Not in the change in law provision. In the change in law provision, if we pursue all the appeals and eventually lose, we start shedding what we pay for. Naturally enough, from OUC's perspective, they would prefer that we start shedding the less revenue-producing capacity purchase, the peaking capacity first. We just shed that. It goes away. Then we start shedding base capacity. If that falls below 75, then the payments for whatever's left, let's just say it's 50 or 40, whatever's left reverts to the demand payments under the existing PPA, which are now in Table 2 of whatever part of Appendix B of Exhibit C it is.
And just how big of a discount are they giving us in percentages? Are we paying a 20% less now or 10% less now?
Well, it's going to take me 26. No, it's that order of magnitude, Scott. Let me do the calculation.
It varies substantially.
It varies,
by the
but
year.
It varies. But for 2016, it's 13,760 divided by 10978, which is 25%.
Okay. So
in some years it's more. I think in the out year, I think at 11,038,
25%,
24%. But it's 23, 4, 5, 8, 39, 30%, depending on the year over the 8-year
So if we
term.
start shedding capacity, we've shed the 54.
Mm-hmm.
For the first 10 that we shed from 85 to 75, we pay the same as the 85. We have the same payment.
We just shed down that. I think we pay the rate under the PPA, whatever it is, depending on the year. If it goes below 75, then it flips to the old.
If we shed 5, so if we 54, if we have to send
it might
59.
Well,
we get rid of all the peaking, okay, and we get rid of 5 of the base. We're still paying for. We're only having to buy 80 base. We're still paying for 85. That's how the take or pay works.
Scott, I think that's right.
Okay. Well, I hope that you know, because you're trying to explain this to me and to the city. If we then go, we're paying the same. If we lose another 6, so now we're buying, instead of 85, we're buying 74, we're paying 7. We're only paying for 74 at the old rate, or are we paying for 85 at the old rate?
74.
Okay, so once we
fall below 74 in this,
we no longer have
scenario,
a take or pay. We're just buying
right. We're back to
capacity
whatever we're buying.
at the old rate.
And if it's 69 or 65 or 60, we're paying the old rates.
Fundamentally, the old contract where we don't have a take or pay.
Right.
Okay. I think, and just, you mentioned briefly last Monday, and we talked about how we had not had a chance to look at your spreadsheets that came up with the $65 million. Does that include, I believe you said that assumes this contract that's before us, not the current contract.
I'm sorry, I did not follow the 2 reference points in your question.
I'm going back to last week.
Yeah.
And we haven't had an opportunity to have a meeting on the spreadsheets where you produced a cost to levelize the. I know how you said it. You said it very
levelizing
the cost to all of our ratepayers if we were to sell to Florida Power and Light.
No, I don't think it would. No, that's two different things.
You changed horses on me there.
I didn't change
I'm with
horses.
you, but
Okay.
please let me know what we're talking about.
What's the assumption?
We talking about the possible sale of the shores?
Possible sale of the shores.
Yes, sir.
13 million, 65 million, different. The difference there. Is this new contract the assumption into that $65 million number? Or is it the existing contract? So is that 85 megawatts of take or pay? And this.
I'm just going to make sure.
Okay.
I
appreciate that.
I've been up here a while. Bill, did you hear the question?
The difference.
The stranded cost, the stranded power supply cost piece of the estimated impact of us losing the shores, selling the shores. That included the cost shift of the reduced sales from on the FUMPA contracts and the OUC contract. It is the new contract at the new demand charges. Is that right?
Yes.
Yes.
Yes. Okay.
It is a new contract. I was pretty sure. I've been up here a long time, and I just want to make sure. Thanks.
Okay.
Of course it is. Of course it is. Sorry.
Okay. So that would make it harder for us to settle this contract. Makes us further apart in settling the lawsuit, but that's an issue for another meeting. Okay. I don't have any other questions about pricing.
I have a question, sir. If we default to the existing contract, how swiftly can we get out of the generation business?
I think you need to ask Mr. Fletcher that question, but it does change things because the transmission system impact study addresses the replacement of Big Blue with the peaking purchase from OUC. If we try to get out of it a different way, it would require a new transmission study. So I'm going to see.
It would still be December 1st. I mean, you're still with OUC regardless, so nothing would change here as far as transmission study. So it'd still be the 1st of December.
And we'd just be buying more from OUC then?
Correct.
Okay, that makes perfect sense, and that would be at the current base product costs, by the way. We could shut down Big Blue. That would change. That would take 54 megawatts out of our existing capacity, which, remember, is a deduction from the amount we pay OUC for. So if you take that out, all of a sudden we'd be buying 54 megawatts of additional base capacity from OUC. Okay, Jim, want to say something?
I was just going to say that's the existing contract. That's the way we're interpreting the existing contract with OUC. They are obligated to provide us the power. If we have the transmission, then they replace what our generation would be. So that would be the assumption that Ted's working on, is that, yes, we would continue under the existing contract and the power would come in, would not change any dates in the closing of the power plant.
My friend Mr. Mucher wants to say something.
Yeah, I just didn't know if there's any comment. Of course. Mark?
Mark Mucher again. I have to admit that the wait has made it more difficult for me to answer this question, but I'll try and keep it simple. I'm going way back to the change in law provision and a question about that. The way I heard it read and the way it's written, it seems to me that it covers just about anything and that might be deleterious to OUC. And probably the worst example I can think of would be like a carbon tax, or a lesser example would be an EPA regulation that seem to be promulgated regularly, and that would be deleterious to OUC's coal producing capability. And are we supposed to march up to Washington and protest or defend against that? That's my basic question. I did like Scott's proposal to, limit it to judicial decisions, or better yet, judicial decisions that we're a party to. I understand them wanting us to be responsible for filling out our existing lawsuits, or finishing out our existing lawsuits, and I don't know why they would pay for half of that, but that it depends how that question or that negotiation goes. But it just doesn't make any sense for us to defend things that we're not a party to and have no control over. And I'm sorry that you all talked about that and maybe made up your mind so long ago, but that's the way I feel. Thanks.
Well, Mr. Mucha does bring up a point, and this is still hypothetical, but and I brought it up last time. There is a constitutional provision amendment probably going to be on the ballot for 2016, which would allow companies to offer homeowners photovoltaic generating capacity. If that goes through, there are a lot of companies out there who would be willing to come in and take advantage of that, and the change in demand because of the increase of photovoltaic capacity could be quite significant. Is a constitutional change a legal part of this legal legislation effect? How do you claim, or how do you fight a constitutional? How do you fight the constitutionality of a constitutional amendment?
That's a really good question. I think you have to make the argument that it's unconstitutional, either as in conflict with other provisions of the Florida Constitution or as a matter of federal constitutional law.
Okay.
I don't think we should be obligated to be their legal partner by contract. I think we can decide it on a case-by-case basis as the cases come up. This is, to my mind, it's too broad, and I don't think we should be obligated to go to court with them.
Oh, I have some other questions, but I see.
Just have 30 seconds. Just want to point out, thank you, Mr. Stradley, for making that suggestion, but I just want to point out that without that change, and since it looks like you have consensus to make that change, or at least can now see what's so awful that you were asking about that particular section, is that the purpose for that appears to me to be able to limit the options that City of Vero Beach voters have. It is placed there so that in case there is a referendum, the Orlando could deem it necessary, or the City of Vero Beach, to challenge its voters' desire. Furthermore, if there is a statewide constitutional amendment that makes so that that the relationships that exist between OUC and Vero Beach aren't as good under their contract, the City of Vero Beach could have to go fight the referendum. So just understand that while you're looking at this, what you're really doing, what OUC is, OUC heard us OUC has listened to these. OUC knows. Remember, OUC has already said they're not going to object to Indian River Shores. Yeah. So just remember, please, when you're thinking through that last section, that what you're really trying to do is they're trying to get you to make a contract with them that the City of Vero Beach will prevent the voters of City of Vero Beach from doing their will.
I'd like to ask, this gets to our demand from Mr. Fletcher. In regard to the state of the art, whether it be wave power, wind power, solar power, or traditional salt fuels, is what do you see in regard to the future?
Probably answer that would be solar.
And what is the state of the art in terms of all of those to be implemented, say bringing gas to our major customers?
State the question again?
But,
Gas to the...
You need to come up to the microphone.
Say it again.
What is the feasibility of our major customers being able to have access to natural gas in the near term, which is one of the concerns regarding the future growth?
Peter, I'd have to do some research on that to get you a number. I'm not sure.
Well, we've heard about how swiftly this can be done and the impact, and I just am. My personal perspective is I don't think whether the permitting or the rights of way or the investment can be done very swiftly. That's my own personal opinion based upon my knowledge of such things.
It's pretty long process. It's not that easy, yeah.
I have a whole host of questions that the Finance Commission would delve into if there were a new contract. But it also gets into, I mentioned at the last meeting, the whole gamut of what the cost would be to exit the generation and the power plant and mothballing it, personnel costs, how it's going to impact the whole broad revenues and transfers of the city. But that is regardless of the closing down of the plant, as we just heard, of whether this new contract goes into force or not. So that would be relevant for a Finance Commission meeting to get into those costs and impact. But it does not impact the contract of which we're speaking today. That's my comment.
I have a quick question for Mr. Fletcher before he's up here. I understand our plans are to close the plant December the 1st.
That's correct.
Is that, if we don't have this contract or a replacement power, can we reverse that? Can we delay that and defer that? Or is it irreversible now? Is that a...
Well, we can still shut down generation. I mean, transmission study's been done, so...
No, but I'm saying that, can we keep it running past December 1st?
If we choose to, but I don't think that was the...
Yeah, the question is why?
Right.
Because
the cost is going to be greater running the plant than buying.
Only under this revised contract.
No, if we went to OUC, we'd be paying what we're paying now for that capacity, which is still cheaper than running the plant.
Isn't that $8.9 million a year for 54 megawatts of capacity in 16 under the existing contract?
Right, but you've got two things on the running of the power plant. Number one is your just overhead cost that you're doing, which is approximately $4 million a year. The second is your future exposures. Every time we spend capital improvements on that thing, and you call it capital, it's capital investment in trying to keep those units going, would far exceed in any time the purchasing of the capacity. The fact of the matter is, we need to get out of the generation business. We can't afford it. We can't be anywhere competitive in that arena. And it exposes us some horrific costs going forward that, Ted and ourselves have all talked about what we would need to do, just keeping 2 and 5 going.
Well, I certainly don't want anyone to think that I'd advocate staying in the generation business. I just wanted to know about the deadline. I mean, could it be February or March if we needed it to?
Again, there's no reason to put it off. We see no financial reason to put it off.
Good. Thank you.
Mr. Chairman, if I may, it's obvious there are some language issues with the contract that we'd like to address or that we've certainly discussed here at length today. I would propose that maybe we make a list of the language changes that we would like to see if we're going to ask Mr. Wright to go back and have another conversation with OUC regarding this amended contract. Right now, I think the only thing we've really talked about at length was the legislative legal changes in the 50-50 sharing of responsibilities of legal fees. And I'm just wondering, are there other issues like that that are language issues that we might want to have a discussion about here today? Thank you.
Open the floor as to what
I think that's a good idea.
Other language changes.
I mean, if the bottom line,
I understand the law issue.
Right. At the bottom line, if we're going to ask him to go back, I mean, let's go back one time and reconsider the language. So that was my concern.
Well, let me respond to it. As a non-lawyer, I'm not going to be sitting here second-guessing a legal document that a well-paid legal group has put together and Jim and his crew has reviewed. I mean, I'll look at the fundamentals and numbers and make some sense out of it, but I'm not a lawyer, and I don't really want to sit here and piecemeal words on behalf of a legal document. Now, I think while and I think he's got the gist of the problem that seems to be coming out of the committee, and I think he can modify that and work on that and maybe submit it back to a few people for review before he goes back down to try to negotiate this deal to see if it satisfies the people around the table a little bit. But I think if we get into redlining a red line, non-lawyers, it's going to lead us down a really strange path.
But that's what we've been doing.
Gone out of the barn because we did 3 sections, which Mr. Wright already changed. They're detailed in this memo. Separately, Scott Stradley and I had sent emails to the city manager asking for the force majeure clause to be made to work in both directions, and Mr. Wright made those changes. So there's 4 things already that he got accomplished.
Well, that was my point. There are a few people around here that are really expertise like yourself.
I'm not a lawyer.
And here, that maybe makes some sense. But
that was my point. We've spent several hours talking about an item that is a language change in here. And I'm just asking, is there anyone else that has something that they think is a language issue that we could address, because that's exactly what we've been talking about.
I think the thing is they're not really language issues, they're conceptual issues.
Yes, and gas transportation is an example of that. In the existing contract, that will revert back to Vero Beach, and in this proposed contract, it goes permanently to OUC, and I think we're going to obtain additional information on that first before deciding on the language change.
But I think we're right. You're right that we should try and not be going back, nibbling at the cherry time after time. Let's try and get the whole thing done in one shot. So if there are other conceptual problems, we should try and flush them out now.
I think one of the more prime points that you're raising, and our forecast is based on going up 0.5% a year, and what you're suggesting is that's the improper way to run it. If we ran it the other way, 0.5% a year down or 1.5 down, what does that do? That's the first question. And the next question is, your point is...
I'm sorry, just to clarify that point. I don't know what the right forecast is, but I want to see some risk analysis done as to if we do go down, how much we're taking on additional fixed cost on the take-or-pay. How much is that? How's that going to impact things? I'm not sure we're going to go. My gut tells me that power demand is going to go down, given all these changes. But I've got a feeling. But that's one thing that I think is still open at this point before I would recommend, for at least for as far as Utilities Commission is concerned, to make a up or down recommendation on this contract.
See,
I think we need to know that. That's my opinion.
I'm in agreement with that. I would agree with that. I'd also agree that I think it'd be pretty easy for us to take the top 5 of our users and subtract our chief financial officer over there. That's pretty darn good. I suspect she could back out those figures going forward and see what would occur if we lost, let's say, just like you said, if we lost Piper, right? And if we lost Walmart, what does that do to our 85 megawatts? I mean, how far does it drive us down?
3%.
But she can run the figures for us, right?
Remember, it's the difference between megawatts and megawatt hours. We shed all the energy costs if we lose sales.
But the analysis could be run pretty easily, right?
The fixed cost is what remains.
She could rerun the figures pretty quickly based on this.
I sent an email.
It also depends on the starting point, but go ahead.
I sent an email out to Jim on Sunday evening, asking for this again, and I stated, I maybe defined the term, our at-risk customers, which would be the shores, the out-of-city customers. And one of the things that's a little confusing to me are that we hear that the shores is 8% of our customer base and 14% of our power consumption. Is that 14% of our total or 14% of our residential? Residential.
And
which
14% of the power is because of the high usage of residential by the shores. Take out the shores, and the average usage is about 950 kilowatts. The shores alone is over 1,500. So at 1,000, as you know, the second tier of costs come into play. That it's higher if you have over 1,000. So even though it's 14% consumption, it's somewhere between 14 and 20% of the actual total residence revenue of Vero Electric.
That was taken into account in the analysis that staff did.
But that's the point I'm making when people just keep saying it's 8%.
But you have to look at the total system revenue.
Yeah.
You can't break it out between residential and commercial. That has no meaning.
Yes, it does, because it means because you charge by customer class, then all of that $6, $7, $8 million that is lost in revenue in the residential rates has to be picked up by the other remaining 26,000 customers who are residence customers. It just doesn't go away.
Well, that's why I think our staff can do that pretty easily and resolve some of these questions. It would seem
we did. We made a conservative assumption in the analysis of what it would cost us to stay whole if we lost the shores. We made a conservative assumption.
Yeah.
We assumed 8.7%. Probably it's a little bit higher than that, but
I saw your evaluation.
We didn't want to be accused of overstating it.
Well, my point is we're worried about where we're going longer run, and if we just did the same 5-8 year analysis we already have, couldn't we do that pretty easily?
Do what? Sorry.
The 8-year analysis we've got going forward, right, of cash flow,
Yeah.
couldn't that be rerun pretty easily, assuming, like he suggests, a downward trend versus an upward trend?
What I was going to, here's what I was thinking, and Mr. Auerter, hey, here's what I was thinking to do in response to what I understand you want, is to give you a table that shows what the costs would be versus just of the floor provision, with the point of reference being the demand chart for 2016, the point of reference being what it would be at the new demand charge rates with no floor versus what it would be with the floor. So as I said earlier, at 10 megawatts, it's about $1.3 million. At 9 megawatts, it's whatever it is, $1.18 million or X, whatever it is. But I was going to do that 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, maybe 15, maybe 20.
20% drops in demand you're talking
megawatts.
about?
Megawatts.
Oh, 20 megawatts.
Below the floor.
Okay.
And we'll have to translate, we'll have to
Okay.
reverse engineer what that would mean in terms of a reduction in our peak demand, but we can do that. That's
Yeah,
algebra.
and then that
that's
way
algebra.
you
We can
just
do
see-
that. The problem is going to be that'll tell you what the impact would be, but it's very difficult to assign probabilities to those numbers.
Understood.
And like I said earlier, the main line probability, using the same assumptions that 3 other major Florida utilities use, Duke, FPL, and OUC, is that we would never impact the floor at all based on their base case projection. Now, could we fall low enough? Yeah, we could. But the expected value is actually the sum of the probabilities times all the things, and whatever it is. I don't know what the probabilities are, but I can give you the table.
Okay, I look at it more as a worst case scenario analysis.
Mm-hmm.
I think the issue is we're such a small place, Indian River County, compared to like an Orlando utility or an FPL utility. They can balance out having areas which are growing fast, which areas are growing slow. When the smaller you get, the more you are at risk of the bad scenario where everything goes bad at once, because you don't have that diversification of
Correct.
demand. So that's what I'm trying to at least take a look at. And it's more of a worst case scenario, because you're right. The probabilities, you're just kind of throwing something against the wall and see what sticks. So I understand all that, but at least we can say, okay, if we drop 5 megawatts hour, boy, this is really starts to hit us hard, or not, as the case might be. So I think that's a fair way to look at it.
Okay.
My question, and just to clarify it, is I'm curious as how much each one of these customer classes are usually of our base capacity. Our capacity requirements of, let's just for round figures say 200. Okay.
Mm-hmm.
Is the Shores 10% of that, 20% of it, 75% of it? I know it's not 75. Is it 8% of it? Is the Piper, what percent of our capacity do we have to have for Piper, for the mall, for Walmart, and for the what percent of our capacity do we need to have the city, at the city borders, and what's our capacity for everything else? That's the information that I was looking for to evaluate the risk of going into the take and pay.
It's right here. This was handed out. You had handed out in your exhibit number 2 is the amount of kilowatt hours for the 10 largest customers, what the revenue is, and what percent each is of the entire base. So that information is at hand. Pardon?
That's usage, but not peak demand.
No, I understand that. But at least
So it's not the information that I'm asking for. I don't know if you're telling me that it's here.
You were asking how many kilowatt hours they use, and that's what I'm talking about. Now, I understand your differential, but I was saying that part of that information is at hand.
Well, actually, I wasn't asking about kilowatt hours. I was asking about our demand capacity. How much demand are we purchasing for the shores? How much for Piper? But I think that Cindy and Mr. Wright understand my question.
Well, that also asked about the megawatts, which I was trying to address in terms of what the number of megawatts would be reduced. So that obviously has to be overlaid with more granular definition.
I have one more question on the gas transmission. I thought that was brought up that it would now be tantamount to having a sale of these gas rights, and whether that is something that can be done. Was there some question as to whether that would violate something? Or?
That question was raised. I'm going to have to ask the city attorney's office. Ms. Lyons was in a meeting earlier. I hope to get up with her this afternoon before I leave.
Any more comments, public comments, discussion?
Chef, make sure you understand the takeaways. I think there's two. Is that right?
I've got Mr. Stradley's takeaways. Ask to modify 15.11.2 to take out federal and basically to reduce the scope to state judicial decisions. And the second one was...
And to share the legal cost 50-50.
Oh, right, that's right. Thank you.
Yeah,
yep,
right. That would apply to any future state judicial decisions, right?
Okay.
And
then I told you I'd get you the table.
Right.
Yep. And I've told you separately I'll work with you to make sure I understand what you want. But I believe I understand it. But as we discussed, I'll lay it out and we'll make sure that's what you want before I go to the work. We go through the work of filling in the blanks.
Okay, thank you. And then I guess, and Ms. Barton just mentioned
the question as to whether it's lawful for us to give a permanent release of our gas contracts that Mr. Wilson raised. And I told you all I would ask Ms. Lyons that question. Mr. Clement's on his honeymoon.
My question is, how soon do you think you can be able to deal with those issues with OUC?
I'm going to try to deal with them today, but we'll see.
But I'm going to try to deal with OUC on the legal issues before you've run it through my associate here, make him happy.
Well, I think I'm pretty clear as to what the request is. The request is change it to state judicial decisions, take out federal and other administrative, and share the litigation cost of any future litigation 50-50. I can make that ask.
You might ask them to clarify the FTS2 transaction so we can...
The NRG transaction.
Yeah.
It looks to me like they bought the FTS2. Reading the minutes, it looks like they bought the FTS2 capacity from NRG at the tariff rate. That's what it looks like to me, but I can't tell. I will verify that. That's an information question, but I'll find out.
Okay.
All right. Assuming that occurs relatively swiftly, and we get a response from OUC in their stance, presumably you'd bring that back as swiftly as possible to the joint commissions to understand precisely whether there's a best and final offer or whether there isn't.
Yes. I think the guts of the economic guts of the deal are a best and final offer. But these terms are clarifications, modifications, whatever. We're not changing the pricing. We're not changing the term.
And
we're not changing the floor.
My point is that if there's a satisfactory agreement on these clarifications, then do we need another meeting that could be rather swift if, in fact, those demands are met, so that we can jointly or separately, we have to make motions. You can't do it as one entity, in order to understand what the best and final is and go forward with recommendations.
I'd certainly
Yeah,
like
I
to hear
mean,
again.
we need another meeting.
Yeah. I'd certainly like to. You're raising big points, and I think we ought to be involved. Those are financial issues.
That's all I'm saying is that to make it happen as swiftly as possible, so that we don't. If it is advantageous, and every week that goes by is a potential either to have lower rates or not. And it's overlaid by the whole issue of operations that Ted and his team has to go through to make that December 1st event occur.
Sure.
I agree. I don't have any desire, I don't think anybody else does, to delay this process.
I'm with you.
Yeah, all right.
Mr. Arwar, did you receive the information that you had requested last week? Is that in total now? That was part of your motion?
I guess there was a question regarding the long PDFs about getting the underlying spreadsheets, and unless that was in the note to Tammy Vach. I mean, I haven't seen that email yet, so I don't know if that was included in there or not.
Here's the deal on that. This is the content, the working content of those spreadsheets is Mr. Harrington's proprietary business information based on his work throughout the industry in Florida. He does not want that out in public. I have
even though we paid for it.
Correct. Just let me finish. I've discussed this with him. Conceptually, and this is something I need to clear with the city attorney, unfortunately I wasn't able, this was a lot going on. I exchanged emails with Mr. Comment yesterday about this, and I'm trying to get with Ms. Lyons to discuss it today. Haven't been able to do so yet. Mr. Harrington is conceptually willing to let y'all have access to the executable Excel version of the spreadsheet, provided that each of you who wants a copy of it signs an NDA that you won't use it outside these proceedings and you won't disclose it to anybody who hasn't signed an NDA.
Okay.
He doesn't want his other clients or his competitors having that information.
I can
that works for me.
And I'd be happy to do that. I also, though, perhaps part of the reason is it's hard to read. And I don't know if it would work, but I think that you can export from Excel into another format that would, you could eliminate the formulas and just export the numbers.
No, that's what we have currently. That's a PDF.
No, I PDF'd it and then sent it to Tammy.
And then you re-import it back into Excel as numbers. And I'll mention this to Bill later and see if maybe that could work, which would give me an Excel spreadsheet without the proprietary formulas.
I want to see the formulas. As I said in the other meeting, I don't want to be a forensic accountant to try to figure out what's going on. I tried to back into the formulas. I sat in front of my 60-inch television, had my computer hooked up to it to try to read it back and forth. I want to see the formulas. So that doesn't work for me.
That's fine. I'm willing to sign the NDA.
Me too.
Your mic, I think.
Yeah, I'd like to make a motion for the Finance Commission that we recess our meeting until we can have a report back from Mr. Wright's discussions with OUC. Second?
I'll second.
All in favor?
Before you do that, can you tell us what's available, Chef, for you
Is Friday, if we can get the response back?
Friday is available for me. Tomorrow morning's available for me. Wednesday and Thursday are not.
I think we need to give him some time. Friday would be.
Yeah, I wouldn't be real optimistic about tomorrow, but I'm not overtly pessimistic about it either.
The 16th. I'm out of town next
But-
week. The following week.
No, this is this Friday.
Friday's good.
May I go forward with the motion? We have a motion to recess until next Friday, that Chef can get back to us.
Until this Friday.
That's Friday.
Yes.
This Friday, yeah,
Dan?
16th.
Heather, you want to poll the Finance Commission on a motion?
Mr. Gorey?
Yes.
Mr. Brabant?
Yes.
Ms. Barton?
Yes.
Mr. Powers?
Yes.
Mr. Snow?
Yes.
Utilities Commission, do you want to follow the same format?
We can adjourn.
That's fine by me. So,
All in favor?
Aye.
Aye.
aye. Well, do we need a motion and a second or no, or just recess? Okay.
You all set aside the entire Friday. Why don't we try to set a time? About 9 or 9:30 is the Friday morning the best time for folks?
Works with me.
Right.
That sounds
Okay.
fine. Before we close, I just would like to thank Mr. Awar and Mr. Stradley for the additional information. It was very helpful. Thank you.
If for some reason we can't get the information, we will notify and postpone that meeting, because we don't want to have a meeting, just have a meeting. But if he does get the information, we'll
Yeah,
say
and-
9:30 on Friday, same place, same station.
And I would appreciate if any information is available prior to Friday, that the members of the commission have access to that, so that we can evaluate what the information is.
And the press doesn't get it before we do. Please, thank you.
Also, if you have any specific questions, Chef, as he said, his cell phone is available, and please don't hesitate to give him a call. You get the personal discussion.
And Mr. O'Connor, your number is
My
available
number's
as well.
pretty well known as well, yes.
Thank you very much, everyone. We're adjourned.